Back in 2021, Florida Governor Ron DeSantis signed a bill targeting social media companies for the way they try to moderate their content. While big tech firms argue it's their right and responsibility to block hateful speech and misinformation, for example, DeSantis accused these companies of outright political bias against conservative views, amounting to pure censorship.
Silicon Valley is acting as a council of censors. They cancel people. When mobs come after somebody, they will pull them down. They shadow ban people, which creates partisan echo chambers. And honestly, they are some of the major reasons why this country is divided for doing what they're doing.
Texas followed suit with a similar law, but both states face legal challenges. Earlier this month, the U.S. Supreme Court weighed in, keeping the laws on hold and sending the cases back to lower courts, but not without some hints as to how the court sees this case. Justice Elena Kagan wrote that the platforms like newspapers deserve protection from government interference. The principle does not change because the curated compilation has gone from the physical to the virtual world. It was two trade groups representing social media companies that sued Florida and Texas over the new laws in 2021. 3 years later, they presented their arguments before the High Court.
We told the court today that no business, whether a newspaper, a bookstore, a parade, or a website, should be compelled to disseminate messages that it thinks are unsuitable for its audience. The stakes here are very high. Neither Florida nor Texas could escape the fact that these viewpoint dissemination laws would mandate the dissemination of misinformation and disinformation, of terrorist sympathizers, of hate speech, and suicide promotion.
The legal debate heated up after former President Donald Trump was banned from several social media sites, prompting a backlash from conservative groups. While the tech companies argued these state laws infringe on the First Amendment rights of free speech to regulate their own content. We sampled public opinion in Florida about online content moderation.
Yes, I do believe that companies should moderate people's content that they post, especially for marginalized communities. Being myself, there are people who, put out content that could be discriminatory, and if they aren't being moderated or monitored, then it could be harmful for the public.
There are people that have very weird beliefs, like it just gets to your core. So yeah, I think they should. I mean, it goes against freedom of speech and liberty to think, but there are some things that should have a warning, you know?
And we live in a country where like opinions, lies are thrown out there. So it's all about being smarter than the information and not just believing a politician or another person just for posting something up in social media. So I believe I don't believe they should be kicked out.
So until these cases make their way back to the Supreme Court, the issue remains unresolved in both the legal and public squares. The Texas and Florida cases are part of a broader discussion on free speech standards in the digital age, as more cases involving competing rights make their way to the Supreme Court's docket. It's Soledad Perez, CGTN, Miami.